Tenemos ahora la participación de la doctora Melanie O'Brien, profesora asociada en Derecho Internacional de la University of Western Australia. Por 30 minutos, ella expondrá el tema las niñas, los niños y adolescentes como víctimas de esclavitud sexual en el derecho penal internacional. Adelante, doctora Melanie O'Brien.
Muchas gracias. Thank you so much to the International Labour Organization and the Public Ministry of Peru for having me speak at this important event. Before I begin, I would like to acknowledge that I am speaking to you from the Wajak Noongar Budja and pay my respects to elders past, present and future of the traditional owners of the land on which I am, and acknowledge that the land was never ceded. Now, while the focus of this workshop has been on trafficking in persons broadly in a domestic, transnational or international context, I have been asked to focus on children as victims of sexual slavery in international criminal law. So this means that the context of my discussion on sexual slavery is war crimes, crimes against humanity and genocide. In other words, atrocity crime context. Now, the 2020 annual report of the UN Secretary General on Children and Armed Conflict found that in 2020, there was a 70% increase in rape and other forms of sexual violence against children, with over 1,200 incidences of rape and other forms of sexual abuse of children identified in the report. Of course, this is no doubt a low estimate, as many victims of sexual violence do not report the sexual violence due to the stigma and lack of legal protection available to victims. In addition, sexual slavery can be a long-term crime, meaning that victims are not identified until after their release from enslavement, which can even be for many years. The Secretary General's report also noted that 98% of sexual violence was perpetrated against girls, with girls disproportionately affected by sexual slavery and forced marriage. Over the past years, including this year, the UN has reported sexual slavery and forced marriage taking place in conflicts in Central African Republic, Mali, Democratic Republic of Congo, Libya, Myanmar, Somalia, Syria, South Sudan and Nigeria, and by ISIL of Yazidi girls and women. And a recent report from Amnesty International documented sexual slavery in the Tigray region of Ethiopia, including of children. Justice for victims of sexual slavery in past conflicts, such as Bosnia in the 1990s, remains elusive. Atrocity situations also increase the likelihood of girls being trafficked into forced marriages and sexual slavery, such as the current Syrian conflict or the Rohingya genocide with many refugees, as Professor Oosterveld has mentioned, in Bangladesh. Thus, it is clear that sexual slavery and forced marriage are crimes being suffered by children on a substantial scale around the globe. Children merit special protection, as their youth and need for development mentally and physically results in an increased vulnerability and requirement for care, for nurturing, protection, control, and opportunities. There is a developmental process for intellectual growth carried out through experiences and environmental interaction. A child's origins and their socialization surroundings will shape that child into adulthood. Experience and environment thus have a substantial impact on a child's development. However, this development and ability to grow into a physically and mentally healthy adult is severely impacted by sexual violence, particularly long-term sexual violence as experienced in sexual slavery and forced marriage. Many reports on sexual violence in conflict and other atrocity situations have noted the long-term physical and psychological impact on victims. A study of sexual violence survivors in the Democratic Republic of Congo, including sexual slavery, found that victims experienced Physical symptoms including chronic pain, urinary incontinence, generalized malaise, and symptoms consistent with sexually transmitted infections. Survivors of sexual violence in the Tigray region in Ethiopia reported continuing physical trauma such as bleeding, pain, incontinence, rectal prolapse, immobility, and fistulas, and many had contracted HIV. Depression, insomnia, anxiety, and other forms of emotional distress are also common among survivors, as well as family members who witnessed such abuses. These physical and psychological effects may come from reports on two distinct places, but they are common across all survivors of sexual violence in atrocity contexts, who may also end up unable to conceive or to carry children as a result of the physical trauma they experience. Effects can be particularly acute for child victims who are more prone to psychological trauma from sexual violence due to their young age, and thus an inability to process events in the same capacity as adults. For those who are subject to sexual slavery, the repeated nature of the sexual violence means a higher likelihood of long-term physical impact on the victims, particularly as an injured victim is not necessarily a deterrent to a perpetrator to cease the sexual violence. All of this is exacerbated by the lack of access to healthcare to treat physical injuries from the repeated sexual violence, which usually means that for victims of sexual slavery, physical injuries result in lifelong health problems. The crimes of sexual slavery and forced marriage in atrocity contexts disproportionately impact on children as victims, but they also create another category of victim, the children who are born from this sexual violence. Survivors who testify frequently have also been pregnant and given birth to children fathered by their rapist. Studies have found that these offspring are particularly vulnerable. Children born of sexual violence have higher morbidity due to malnutrition, are less likely to be educated, and risk further exploitation and ostracization. For example, I interviewed a Bosnian survivor of sexual slavery and forced marriage, whose child born of that forced marriage experienced constant verbal abuse throughout his childhood because his father was Serbian. As children of the so-called enemy group, children born of sexual slavery and forced marriage are stigmatized and ostracized from their communities, leaving these children and their mothers, who may also still be children themselves, on the desperate outer fringes of society without proper access to education, family, healthcare, and development. So that's the context in which we walk into international criminal law. And I'd like to talk about the international criminal law side of this now. So in international criminal law, sexual slavery, as Professor Oosterveld has covered, is defined as a specific form of enslavement where the perpetrator restricts or controls the victim's sexual autonomy whilst held in enslavement. So this crime has two main components. Firstly, the enslavement elements, namely powers attaching to the right of ownership, such as purchasing, selling, lending, or bartering a person. And secondly, the perpetrator must cause such person to engage in one or more acts of a sexual nature. And as Professor Oosterveld has also referred to, the definition of sexual slavery under the elements of crimes of the Rome Statute of the International Criminal Court includes a footnote that declares that this definition includes trafficking in persons, in particular women and children. Now, I think this is actually highly problematic, as human trafficking and sexual slavery are two very distinct crimes. Compared to the definition that I've just given you of sexual slavery, human trafficking is about moving a person from one place to another, including across borders, and may have no connection to sexual violence. It could be, for example, focused on forced labor. But this has yet to be tested in any of the case law of the International Criminal Court. And I'm sure it will no doubt be problematic if there are charges brought for human trafficking under this rubric of sexual slavery. I think it will be a real challenge for a prosecutor to prove this under the definition. Now, in international criminal law, there have been cases involving sexual slavery and or forced marriage before the Special Court for Sierra Leone, the International Criminal Tribunal for the former Yugoslavia, the Extraordinary Chambers in the Courts of Cambodia, and the International Criminal Court. While sexual slavery and forced marriage are not the same thing, they do overlap, and the discussion in the international jurisprudence has had some overlap. So for this reason, I'm also going to discuss forced marriage in this presentation. Forced marriage is not a specific crime enumerated in any statute of any of the international criminal courts or tribunals. And a discussion of the issues that this has raised is outside the scope of the presentation from me today, but I'm happy to share with anyone the literature on this. Consequently, it has been up to the judges to create a definition of forced marriage using the crime against humanity of other inhumane acts. Currently, it can be said that the definition of forced marriage is the imposition of marriage status on the victim and the imposition of duties that are associated with marriage, as well as consequent social stigma, but there is no requirement of an official or formal marriage. Forced marriage may, but does not have to, contain acts of sexual violence. However, all of the case studies that have been prosecuted at international level have involved sexual violence, which is why forced marriage and sexual slavery have been seen to have some common elements. I will also make reference to the crime of rape in this discussion, as rape forms a principal element of sexual slavery and, in the relevant case studies, also forced marriage. Now, one of the challenges of analysing the situation of children as victims of sexual slavery and forced marriage in international criminal law is that there is generally not a focus on the children. So usually what we see is the combination of a victim category of women and children, or girls and women, as a victim group. So despite the fact that children are a specific and vulnerable group of victim distinct from women, they tend to be combined as one category of victim. And this can result in a lack of emphasis on children as victims, on their youth, their vulnerability, and the subsequent long-term impact of the crimes on them. Now, looking at the International Criminal Court elements of crimes for the crime of rape, it defines rape as occurring when a person is incapable of giving genuine consent, which includes age-related incapacity. However, the document does not specify the age under this age-related incapacity. So we need to look elsewhere. So to start with, we look at the Office of the Prosecutor Policy Paper on Children, which says that the Office of the Prosecutor considers children to be persons who have not yet attained the age of 18. Therefore, anyone under 18 is a child. This differs from the age of 15 as the permitted age for recruitment into hostilities, but this is the only specific provision that uses a younger age than 18. The International Criminal Court also does not prosecute anyone under the age of 18. The Convention on the Rights of the Child also defines a child as someone below the age of 18. Likewise, the International Labour Organization, in its convention concerning the prohibition and immediate action for the elimination of the worst forms of child labour, defines a child as a person below the age of 18. Notably, this ILO convention considers all forms of slavery to be one of the worst forms of child labour, along with child prostitution. Thus, it can be assumed that 18 is the age of adulthood, and that this concept of age-related incapacity within the International Criminal Court's statute means under the age of 18. So essentially, when we look at the case law coming out of international criminal law, it seems that the importance of children being victims comes into play for the most part in sentencing decisions. While the young age of victims is mentioned in trial or appeal judgments, I want to look here at the sentencing decisions, which is where the age of the victims really becomes a focus. I will look briefly at some cases from the International Criminal Tribunal for the former Yugoslavia and the Special Court for Sierra Leone before turning in more detail to the International Criminal Court. A brief look at the International Criminal Tribunal for the former Yugoslavia. Now, the ICTY had minimal provision in its statute and its rules and procedure for sentencing. So the only thing we find is Article 24 of the statute, which required the court to take into account factors such as gravity of the offence, but it does not provide any further explanation of the concept of gravity, nor is this covered in the rules of procedure and evidence. So in the Focha case, the facts of the case centered around the Partizan Sports Hall, which had become a rape camp including children. And this case resulted in convictions for rape and enslavement. And the reason for this was that the ICTY statute does not contain a specific provision outlawing sexual slavery. So because of this absence, the ICTY was obligated to bring together the two crimes of rape and enslavement as the best way to encompass what was actually essentially sexual slavery. Now, in this case, in the Focha 2002 appeals judgment, the court affirmed the decision of the trial chamber to consider the vulnerability of the victims in its sentencing decision, including their age, as part of this gravity of the offence. And the tribunal held that it was appropriate for the young age of the victims to be taken into account when sentencing. Moving on to the Special Court for Sierra Leone. Now, as Professor Oosterveld has mentioned, sexual slavery was a prominent feature of the conflict in Sierra Leone in the 1990s and 2000s, with many women and girls as young as 10 years old taken as so-called bushwives for soldiers. Now, it is through the case law from the Special Court for Sierra Leone that the debate over whether forced marriage should be prosecuted as sexual slavery or other inhumane acts was held, with differing decisions emerging from the case law. However, for the purposes of today's discussion, it must be noted that the forced marriage in Sierra Leone did include a sexual slavery component, and the Special Court held that the victims of sexual slavery and forced marriage endured particularly prolonged physical and mental suffering as they were subjected to continued sexual acts while living with their captors under difficult and coercive circumstances. Due to the social stigma attached to them by virtue of their former status as bushwives and the effects of the prolonged forced conjugal relationships to which they were subjected, these women and girls were too ashamed or too afraid to return to their communities after the conflict. Accordingly, many victims were displaced from their hometowns and support networks. So here the court was recognizing the short and immediate term effects of the forced marriage, but also the long-term effects. When it came to sentencing, the Special Court for Sierra Leone was obligated to include an assessment of the gravity of the crimes, similar to the ICTY. In the sentencing decision in the RUF case, the chamber observed that many of the victims were particularly young and vulnerable, and that the majority of the victims of forced marriage, rape, and sexual slavery were young girls of school-going age or village women. The court also recognized that the physical and psychological effects of the forced marriage and sexual slavery were ongoing, and that these were particularly grave crimes because the victims were forced to live with their captors in a hostile and coercive environment. The survivors who testified expressed deep shame and stigma which they feel and face to date several years after the abuse. One victim witness had to take regular breaks during her testimony due to physical ailments caused by the sexual violence she experienced. And the court found that the victims of sexual violence continue to live their lives in isolation, ostracized from their communities and families, unable to be integrated and reunited with their families and/or in their communities. Many of these victims of sexual violence were ostracized or abandoned by their husbands, and daughters and young girls were unable to marry within their community. These factors, importantly, led the chamber to conclude that the gravity of the criminal acts in question is exceptionally high, and the defendants were sentenced separately to terms in prison for sexual slavery of 15 years, 30 years, and 45 years. This was dependent on each of the three defendants' roles, with the higher terms reflecting a greater role and the gravity of the offence. In another case out of the Special Court for Sierra Leone, Charles Taylor, who was the president of Liberia and was involved in the conflict in Sierra Leone, was convicted of sexual slavery as well. In his sentencing, the court acknowledged that part of the gravity of the crime was that there were victims with particular vulnerability, including children, and they made special reference to young girls who have been publicly stigmatized and will never recover from the trauma of rape and sexual slavery to which they were subjected, in some cases resulting in pregnancy and additional stigma from the children born thereof. Charles Taylor was sentenced to 50 years in prison, which was upheld on appeal. I'd like to move now onto the International Criminal Court's cases on forced marriage and sexual slavery. And there are several cases before the ICC that have dealt with or are considering sexual slavery and/or forced marriage. And these are relating to situations in the Democratic Republic of Congo, Uganda, and Mali. And similar to the other courts, to date, it is really the sentencing decisions where the court has focused on the specific nature of children as victims of these crimes. The International Criminal Court's Rules of Procedure and Evidence have Rule 145, which regulates factors in determination of sentence and rules that the court shall take into account commission of the crime where the victim is particularly defenseless. And we'll see that applied in these cases. I'd like to start with the Uganda case, and this case focused on war crimes and crimes against humanity committed in the Democratic Republic of the Congo. And Professor Oosterveld has given you an excellent introduction to the case. In the Democratic Republic of Congo, sexual slavery of children, particularly girls, by soldiers is frequent due to substantial presence of combatants in areas where there are high rates of illiteracy and poverty. A report by MONUSCO, the peacekeeping operation in the Democratic Republic of Congo, that assessed children and armed groups in the period of 2014 to 2017, found that girls associated with armed groups are subject to sexual slavery and forced marriage. At least 56% of girls recruited into armed groups had experienced rape, sexual slavery, or forced marriage, with 75% of girls taken by the armed group, Kivu-based NDC Renové, and 92% of girls who were recruited by the Ituri-based armed group, FRPI, were subject to sexual violence. The report noted a 14-year-old girl who was abducted by the FRPI and given to a commander as his wife. One girl was taken by the FRPI at age 14 or 15 and was forced into a marriage for over a year until her so-called husband surrendered. But at 16, she was pregnant with his child. A 17-year-old girl was taken by the armed group NDC Renové in North Kivu and given to a commander as a sexual slave. She fell pregnant, but she lost the baby after being made to engage in fighting against another armed group in which she was shot in the stomach. These are just 3 examples of survivor stories in the report, which found that 95% of victims of sexual violence from armed groups in the DRC were girls. Now, in the Ntaganda case, Ntaganda was convicted of sexual slavery of girls, both civilians, but also child soldier members of his own military group. All the child soldier victims were under the age of 15 when they were subject to sexual slavery. The court referred to the statute and rules according special status to sexual violence crimes, crimes against children and the victims thereof, and the court noted the especially grave nature and consequences of sexual violence crimes, in particular against children. So in determining the sentence, the court acknowledged that the evidence demonstrated that the victims suffered short and long-term physical, psychological, psychiatric, and social consequences. In particular, stigmatization was a very significant issue, with victims fearing rejection from their own communities, including an inability to marry, as no man would marry a rape victim. One of the civilian victims of sexual slavery in this case was an 11-year-old girl. The chamber considered the victim's age to constitute an aggravating factor. This reasoning was also applied to the sexual slavery of child soldiers, where the particular defenselessness, drawing on the rules of procedure and evidence terminology, the particular defenselessness resulting from their young age was considered an aggravating factor. A sentence of 12 years was imposed for sexual slavery of the civilian victims and of 14 years in prison for sexual slavery of female members of Ntaganda's own armed group under the age of 15. Ntaganda was ultimately, though, sentenced to 30 years in prison, and this was confirmed on appeal. But it's really interesting to note that only last year in 2020, 3 armed group commanders were convicted in domestic trials in the Democratic Republic of Congo for crimes including sexual slavery, charged either as a war crime or a crime against humanity. 2 were sentenced to life in prison and a third to 20 years imprisonment. And this may represent the influence of the International Criminal Court encouraging domestic prosecutions for sexual violence. Next, I'd like to talk about a case that Professor Oosterveld has also introduced, which is the Ongwen case, related to the crimes committed by Dominic Ongwen, who was a very high-level commander in the Lord's Resistance Army. And this looks essentially at crimes committed in Uganda. So Dominic Ongwen was convicted of forced marriage and sexual slavery relating to girls and women who were abducted by the Lord's Resistance Army, including very young girls. They were kept in forced marriages, which also included sexual slavery, where the girls and women were required to be constantly available for sexual activity for Dominic Ongwen or for whichever Lord's Resistance Army soldier was their allocated husband. Now, in the Ongwen sentencing judgment, the court held that the young age of the victims was an aggravating factor for sentencing Ongwen for the direct commission of the crimes of forced marriage, torture, rape, sexual slavery, and enslavement, which they deemed applied to all these girls. And the court said, the chamber considers that the victims of the crimes were particularly defenseless within the meaning of Rule 145, and that the relevant aggravating circumstance is therefore present as concerns these crimes under consideration. Indeed, all 7 women were abducted and suffered the crimes under consideration at a young age, with some of them being only children at that time. The court then went on to list the ages of the victims, and it included a victim who was only 7 years old when she was abducted and 12 years old when she became Dominic Ongwen's wife. Another one of his wives was 11 years old. When pointing this out, the court said that Dominic Ongwen was obviously aware of the fact that the 7 girls were of a young age, making them particularly defenseless with respect to the crimes committed against them. And in fact, he even intended the girls abducted by or distributed to him to be of such a young and vulnerable age. In relation to crimes that Dominic Ongwen committed indirectly or with others, in other words, where it wasn't his wife, the court considered the very young age at which many of the concerned women and girls were subject to the crimes and of which Dominic Ongwen was fully aware. And they considered this to be an aggravating circumstance in his sentencing, again, for forced marriage, torture, rape, sexual slavery, and enslavement. And really importantly, in the overall sentencing decision, the court took into account as an aggravating factor the large number of children who were abducted, either as child soldiers or into forced marriage, which included sexual slavery. The court highlighted that as children, they were particularly defenseless. So taking these extensive crimes against children into account, the court held a joint sentence of life imprisonment would surely be in order in the present case. Now, while Ongwen's final sentence was reduced to 20 years for reasons related to his background as a child soldier, it remains relevant and incredibly crucial that the court did acknowledge, and it took particularly seriously, the fact that the crimes were committed against children, and that if it weren't for those mitigating circumstances, he would have received a significantly higher sentence than he did. Now, the last case I will look at very briefly is the Al Hassan case. And this is relates to charges of forced marriage carried out by Ansar Dine and Al-Qaeda in Mali. The confirmation of charges document for this case revealed a systematic perpetration of forced marriage of girls, including the use of police and other authorities as intermediaries to pressure families to marry off their girls. Girls and women were threatened with violence or death by armed men and subsequently raped within these so-called marriages. These marriages were to mix the jihadists with the local population to create a new population, and also to legitimize sexual assault through which the needs of the members of the armed groups were granted as a reward. The case is yet to go to trial, but it will be an incredibly important case to watch in terms of consideration of child victims of sexual slavery and forced marriage. So that's the case law coming out of international criminal courts with regards to children as victims of sexual slavery and forced marriage. And to conclude, there is ultimately a need for more research into children as victims of sexual slavery, forced marriage, and also sexual violence generally in international criminal law. Because what we see in the jurisprudence is a passive feminization of children and infantilization of women through the repeated victim categorization of women and children. Women and children are not considered separately as victim groups, even though each has very specific characteristics. Sexual violence crimes against children are thus not highlighted in trial and appeal judgments that they are specifically grave in that they are perpetrated against the most vulnerable group in society. It is only in sentencing decisions that a focus is put on the specific vulnerability of children, with a recognition that these crimes are particularly grave and therefore merit a higher sentence. But as you can see from the sentences that I have mentioned throughout this talk, there is a great variety in the sentences that are actually given to people. So there needs to be more consistency in the sentencing for these particular crimes. The evidence is also that sexual slavery and forced marriage in atrocity context is highly gendered, with women, but mostly girls, being victims of these crimes. Thus, the intersectionality of age and gender is a key factor in victimization for sexual slavery and forced marriage, with girls being the vast majority of victims of these crimes. There is a need for greater recognition from international criminal courts of the gendered nature of sexual slavery and forced marriage, which amounts to a form of gendered persecution of girls and women. Sexual slavery and forced marriage are not one-off crimes. They are crimes with a lengthy duration from days to years, under which vulnerable young victims are forced to live with the person who is carrying out regular rape of them, making these particularly grave crimes with a significant impact on the victims. In my introduction, I noted multiple atrocity situations, including armed conflicts, in which there is sexual slavery and forced marriage of children, predominantly girls, as well as an increased risk of girls being trafficked into sexual slavery and forced marriage to flee these atrocity situations or the poor conditions of refugee camps. This demonstrates that sexual slavery and forced marriage are a prominent and ongoing problem that should form a part of any investigations and prosecutions into those situations by the International Criminal Court or any other court or tribunal taking steps for accountability, which would comply with the ICC prosecutor's policy on prioritizing crimes against children and sexual violence crimes. Including this conduct in prosecutorial charges will highlight the importance of justice for such crimes against children who are particularly vulnerable and suffer long-term psychological, social, and physical effects from sexual slavery and forced marriage. Thank you.
Agradecemos la participación de la doctora Melanie O'Brien, profesora asociada en Derecho Internacional de la University of Western Australia. Enseguida pasamos a la ronda de preguntas a cargo de la doctora María Carmela Horna Torres, fiscal especializada en delito de trata de personas. Ella tendrá un tiempo de 15 minutos. Adelante, doctora María Carmela Horna Torres.
Buenos días. La primera pregunta es para nuestra ponente Valerie Oosterveld y es la siguiente. ¿Cómo podríamos diferenciar la esclavitud sexual de un caso particular de violencia sexual que constituya, por ejemplo, violación sexual? ¿La privación de libertad prolongada es un elemento que debe ser tomado en cuenta? Tiene usted 3 minutos para responder la pregunta. Adelante, Valerie.
Thank you very much. If I understand the question correctly, you are asking about how the sexual exploitation and trafficking fit together. Is that, do I understand correctly?
La pregunta es ¿cómo diferenciar la esclavitud sexual de un caso de violación sexual pura?
Oh,
¿Tiene que ver allí la privación de libertad prolongada o no?
I see. All right. So to differentiate sexual slavery from other forms of sexual violence, sexual slavery needs to satisfy certain elements. And the elements are, first of all, the general requirement with respect to enslavement. And enslavement can occur anywhere. There is not a specific requirement that the victim must be, for example, captured and taken to another location. They could, in fact, be sexually enslaved in their own residence. The definition of enslavement is the exercise of the powers attaching to the right of ownership over one or more persons, such as by purchasing, selling, lending, or bartering that person, or imposing upon them some kind of deprivation of liberty. And then there must be a sexual aspect to that, which is often related to forced rape. So sexual slavery in and of itself doesn't require that the victim, for example, victims be gathered up and kept in some kind of prison, although it often happens that way. As we saw in the Kunarac case at the Yugoslav War Crimes Tribunal, the girls were kept in an apartment, kept in a house, for example, and that could in fact be it wasn't in this case, but it could in fact be their own house. I hope that that answers the question.
Muchas gracias. Ahora, la segunda pregunta es para la ponente Valerie Oosterveld y es la siguiente. En la jurisprudencia de las Cortes Penales Internacionales, han habido casos en los que se considere explotación sexual el brindar dinero a cambio de tener relaciones sexuales con menores. Tiene 3 minutos para responder la pregunta. Adelante, Melanie.
Thank you. Unfortunately, there hasn't been an exploration of sexual exploitation using that specific definition in international criminal law. And this is something that I have looked at quite extensively in the context of peacekeepers. And I found that there is specifically a lack of this specific crime, sexual exploitation, as we think of in the way that, for example, the UN Secretary General has defined it, as you have mentioned, the exchange of money or goods for sexual favors. And we've seen that as a significant problem being committed by UN peacekeepers, we're talking about in the context of international conflicts and post-conflict situations. So it is my belief that this is something that the International Criminal Court should and could look into, but there are challenges as to how they could prosecute it because there isn't a specific provision for sexual exploitation in that way. But I think that between Valerie and myself, we've been through talked through the provisions that do exist relating to sexual violence, which could be used. So, for example, rape, or just the broad concept of sexual violence. But the problem is it doesn't capture the power differential that exists in a sexually exploitative relationship. And that's what is missing. And it's my belief that a standalone crime of sexual exploitation should be added into the statute to be able to capture this. And that applies whether the victims are children or adults.
Gracias, Melanie. La siguiente pregunta es para Valerie Oosterveld. Considerando que el Estatuto de Roma también define la prostitución forzada, díganos, ¿existe algún precedente en la jurisprudencia penal internacional en el que se haya desarrollado su definición? ¿Cómo se define y cómo se diferencia de la esclavitud sexual? Tiene usted 3 minutos. Adelante, Valerie.
Thank you very much. That's a very interesting question. The crime of forced prostitution was included in the Rome Statute because it was taken from international humanitarian law or the law of war. It's listed in the Geneva Conventions. So when the Rome Statute was being negotiated, they were bringing together definitions or terms that had been used in other treaties, and they putting them into the Rome Statute, one of which was forced prostitution. But forced prostitution has not been prosecuted since the founding of the modern day international criminal tribunals. It was prosecuted just after World War II in tribunals that related to events that happened in Asia, but the definition of forced prostitution wasn't elaborated in the prosecutions there. Forced prostitution was under some debate, I must say, during the drafting of the Rome Statute of the International Criminal Court. I was lucky enough to serve on the Canadian delegation to the Rome Statute negotiations. And there was discussion as to whether or not we should remove forced prostitution because perhaps sexual slavery covers forced prostitution. Perhaps it's incorporated within sexual slavery. But the feeling amongst the delegates was there could be a situation in which an individual was not exercising all of the powers attaching to the right of ownership over a person, but at the same time facilitating forced prostitution. And it was therefore left in case a situation arose where the requirements of sexual slavery weren't met, but there was still a situation in which a person was forced to provide sexual services for some kind of exchange. But we haven't had any prosecution, and therefore we haven't had any jurisprudence getting deeper into what that means.
Muy bien. Gracias, Valerie. Y la última pregunta es para nuestra ponente, Melanie O'Brien. Es la siguiente. ¿Cuáles son los aspectos centrales para identificar un supuesto de matrimonio forzado de niñas? Tiene 3 minutos, por favor. Adelante.
Yeah, this is an important question, and this was heavily debated in the Special Court for Sierra Leone, because initially it had been, the goal was to prosecute this as sexual slavery. So the first trial, they actually, the conviction was for sexual slavery. And this is where the debate came around, because they were arguing that actually what forced marriage is about this marital or conjugal relationship and not about the sexual side of it, because the crime might not actually entail sexual violence. So how it is identified is, as opposed to sexual slavery, is that it also includes marital duties. So for example, the girls are made to keep the house clean and to do the cooking. And although, as I mentioned, in all the cases, they were also forced to provide sexual services for their so-called husband. But they were called wives, and they were deemed as being married, even if there was no formal ceremony. And when forced marriage took place, and I didn't talk about this, but because of time, but under the Khmer Rouge in Cambodia in the 1970s, when the forced marriage took place, there was a ceremony held, but it wasn't a traditional Buddhist ceremony. And that was something that in itself was very upsetting to the couples involved. And the way that the forced marriage happened was that multiple couples were brought together, and there was a mass ceremony where all of the people present were forced to pledge their allegiance to the Khmer Rouge. So it wasn't what you would call a proper marriage ceremony. And in none of the other cases had there been a proper marriage ceremony. So that's a specifically not a requirement, but it's the portrayal of the relationship as a marriage. It's, referring to the girl or woman as their wife and requiring her to do marital duties like look after the household, provide sexual services, look after their children as well. So that's the aspect of it that the courts have ultimately narrowed down on, this marital duties rather than the sexual component in forced marriage.
Gracias, Melanie O'Brien. Adelante, José, con la conducción.
Muy amable. Agradecemos a la doctora María Carmela Horna Torres por su participación, así como también a nuestras ponentes Melanie O'Brien y Valerie Oosterveld.